Well, good morning and welcome to our second Gough Square live interactive broadcast. This time our pre-show entertainment has been slightly different, I am told. Perhaps that's a good thing. Anyway, I'm Crowe, and today you'll be hearing from my colleague Alison Lambert on consent, connivance and neglect in trading standards cases. Issues such as what do they mean, which do you choose for your case, what's the difference, and how do you prove the relevant element will be discussed. We will once again be trying to make this interactive through the use of web chat, so sign in and get typing with those questions. Top prize to Tim Cook already, who's already signed in and been tapping away. But be warned, if you're tapping away to ask what a quick fix is to any technical problems, I'm extremely limited in my knowledge and will probably ask you to simply try turning your computer off and on again. But that said, I shall turn to my screen in anticipation of clever questions and leave you in the hands of Alison.
Good morning, everyone, and my suggestion, if there's any technical issues, will be Control-Alt-Delete. So there we are. This morning we are broadcasting Season 1, Episode 1. I'm calling Jonathan's broadcast 2 weeks ago the pilot on this. And previously on Gough Square Live, you've had expletives and then Jonathan Kirk talking to you about time limits, and the two were not mutually exclusive. So this morning, if I could see slide 1, please. This morning we're going to break this down into a few different areas. Again, this is another highly problematic area, and it's an area that is often an area of challenge from the defence, and it's an area that's far from straightforward. One question that's often asked is, does the company need to be prosecuted? What you need to know for the mens rea for consent and connivance, what is needed to prove consent, and what is the situation if there's more than one director. So those are the areas that we're hoping to cover this morning. And if I could immediately turn to slide 2. Slide 2 sets out a statutory provision, and now the provisions are found in numerous pieces of legislation. And the example that I've put on the screen is Regulation 15 from the CPUTs. Now, Regulation 15 says, where an offence under these regulations committed by a body corporate is proved A, to have been committed with the consent or connivance of an officer of the body, or B, to be attributable to any neglect on his part, the officer as well as the body corporate is guilty of the offence and liable to be proceeded against and punished accordingly. Now, further examples are found, not always in exactly the same wording, but along the same lines. For example, in Section 40, Subsection 2 of the Consumer Protection Act of 87 and Section 36 of the Food Safety Act of 1990. Now, there are also provisions which deal with consent or connivance only, and so it's therefore important to always look at the statutory provisions to see whether you have neglect as an option. And two examples there are Section 101, Subsection 5 of the Trademarks Act of 94 and Section 12 of the Fraud Act 2006. Now, the wording you've seen there for Regulation 15 says an officer of the company. So again, you have to consider who can be an officer. The legislation under CPUT specifically provides that it can be a director, a secretary or a manager, or any person who's purported to act in any such capacity. So you're not just confined to directors. You can look at, for example, a company secretary or a manager, again, who's purporting to act in that capacity. Now, do you have to charge the company? Well, it's desirable, but it's not mandatory to charge the company when you're also charging directors or secretaries, etc. However, if the company is not charged, you will have to still prove that the company would have been found guilty of the offence as well. Now, if I can look at slide 3, please. And now here, slide 3 sets out 6 cases, and the principles for consent, connivance and neglect have developed from the case law over the years, and they first appeared in the 1970s, where the first real assessment of the law in this area was in the well-known case of Huckabee and Elliott. So while some of us were speeding around on our choppers on that occasion, wearing our flares, we had the High Court looking at this issue of consent, connivance or neglect. I'm then going to take you through Hersher and Birch, the Attorney General's Reference Number 1 of 1995, the Crown and P, which is sometimes known as the Crown and R, I think, for unknown reasons, R versus Chargot, if we're pronouncing it in the French fashion, or Chargot, if we're not, and the last case, Hutchins and Charalambous. So you'll see that this case law goes over 4 decades, going from 1970 right up to 2011. So the first case, Huckabee and Elliott, I'm sure is a case you'll all be very well familiar with and certainly heard of. Now this is a case where Mr. Justice Ashworth assessed what the stipendiary had said in the court below when he dealt with consent connivance, and he agreed with the propositions that the stipendiary put forward. And it's worth telling you what those are, because they quite easily and well sum up the definitions. Consent, the stipendiary had said, the director consents to the commission of an offence by his company. He's well aware of what is going on and agrees to it, and that would seem fairly obvious. Connivance, the stipendiary said, he is equally well aware of what is going on, but his agreement is tacit, not actively encouraging what happens, but letting it continue. So a sort of blind eye situation. Now, Mr. Justice Ashworth, having agreed with the stipendiary's analysis there, then went on to say, as far as neglect was concerned, that neglect is not a failure to see that the law is observed, but rather the prosecution has to show the director was guilty of any neglect to do what they ought to have done. And those words are very important, and we're going to come back to those in the rest of the case law. The words ought to have done, or words that are very similar. And these are very helpful words if you're looking at a director and whether you are trying to decide to charge with consent or connivance or neglect. So the facts in the case of Huckabee were a club which had to have a licence to run card games. The club didn't have the requisite licence, and certain directors were charged by their consent or connivance, and they had pleaded guilty. The further director, Mrs. Huckabee, was charged by her neglect. Now, the High Court found that she had no knowledge that the club had not obtained a licence, and her only real knowledge was that she knew money had been set aside by the club for the purpose of obtaining licences and other technical issues. They said in the circumstances she knew very little in reality about the conduct of the club, and that another director, the club secretary, was far better acquainted with the business and therefore far better placed to take responsibility. And the court also found that in the circumstances, Mrs. Huckabee had no reason to mistrust this other director and what he was doing. And so to put the definition of neglect into context in this case, Mr. Justice Ashworth said that Huckabee knew the question of obtaining a licence had received the attention of the company by one of the other directors, but it would be wrong to say she was neglecting her duties if she failed to make a specific inquiry as to whether the licence had been obtained. So what is clear from this case is that consent and connivance require knowledge, and what will become apparent is that neglect does not. This case also raised important principles about where there's more than one director that's charged. And the court overall decided that there's no duty on the director to supervise their fellow directors or even acquaint themselves with all the details of running the company. And they felt it was perfectly proper to leave matters to another director, and there was no obligation to test the accuracy of what the other director was doing or saying, unless there was a reason to mistrust that director. And that mistrust came firmly to the fore in the next case we're looking at, which is the Hirschler and Birch case. So we've jumped forward 17 years, we're now at 1987, and this case involved two directors, one who was prosecuted and one who wasn't. Director 1, we'll call him, that was the defendant, wanted to import brake lights into the UK from Holland. Now, when he first made his inquiries about these brake lights, he was told that they might not be legal in the UK. So he asked his fellow director, and we'll call him Director 2, to carry out some inquiries to establish whether the lights were legal in the UK and whether they could sell them. But importantly, when he had this discussion with Director 2, Director 1 said that he wasn't sure about these lights. In due course, Director 1 was told by Director 2 that they were legal to sell, but Director 1 didn't ask Director 2 what inquiries he'd made, and it transpired that the inquiries had been very superficial and had not been at all diligent. Director 1 was convicted by his neglect in that he failed to ensure an authoritative answer to this issue. He appealed on the basis that he delegated his responsibility to Director 2, and he was entitled to rely on that delegation. And as Huckabee and Elliott showed us, that could be a scenario which would absolve him from liability. However, the court upheld his conviction on the basis that he did not do what, we have these words again, but in this case, he should have done. And that's important, again, that phrase coming up. So he was on notice about the legality of the lights, and there was a question mark over them, but he simply accepted what Director 2 told him, And the court said that wasn't good enough. When he had a question mark in his mind, he was then under an obligation to actually make inquiries. The third case, Attorney General's reference number 1 of 95, the directors here were charged by their consent to the company carrying on a business where deposits were being taken from clients without authorisation, which was required under Section 3 of the Banking Act of 1987. And the Attorney General in this case sought the opinion of the Court of Appeal on the question of what mens rea was required for consent to be proved. Now this case is very important when we're looking at consent and connivance, because it said that the director must be proved to know the material facts which constitute the offence and to have agreed to its conduct of the business on the basis of those facts. Therefore, actual knowledge of the exact nature of the offence is needed. So to put in the context of this case, the director had to know the acts, the taking of deposits, were taking place by the company, and the company wasn't licensed. This case also said that ignorance of the law and its requirements, a well-known principle, is no defence. And interestingly, in this case, the court said that if there was no licence, then the directors could be taken to know that they were operating without a licence, and it did not matter if they said they didn't know they needed one. And actually, when you analyse that, that does make perfect sense. So we move on, again, now we're in the 2007, to the case of the Crown MP, and this was actually a health and safety case involving an accident at some docks where a 6-year-old boy was killed after being thrown from a forklift truck. Now, apparently this practice was commonplace at the docks, but there was no evidence as to whether the director, in this case, actually knew it was commonplace or whether it was commonplace just amongst the employees. The court below had put in place a subjective test that shutting your eyes to the steps you could take was the proper test. But actually the Divisional Court said that that was not correct, and they disapproved of that test. The test that they said was correct had come from a previous case, the case of Wotherspoon, and it is decided in that case that the director had failed to take some steps to prevent the commission of an offence if those steps either expressly fell or should be held to fall within the scope of his functions. So what you need to do here is you have to look at the circumstances of the case as a whole. You can look at the knowledge the director might have, but you can also look at whether the facts show you that the director ought to have been aware, those words again, of what was going on. And in this case, there was no actual knowledge that could be proved that the director knew what was happening. But what had to be looked at was, were the surrounding circumstances sufficient in his role as a director to put him on notice that he ought to be doing something towards it. The court stated the prosecution did not have to establish the director knew of the practice, but whether the circumstances ought to have put him on inquiry as to the practice going on so he could put steps in place. The case of Shargot, another health and safety case. This time a driver was killed while driving a dumper truck on a building site. This case is important for one reason. The court decided that if a director was close to the coalface, as they put it, you might need less evidence to prove consent, connivance or neglect than a director who works remotely away from the workplace. And again, this shows the importance of looking at the circumstances in each particular case. This case also established that consent can be established by inference as well as proof of express agreement. And in this instance, the court said that if there's an accident, there's an inference that there's consent or connivance or neglect on the part of someone within that company. The last case is a quite recent case, 2011. This is the case of Hutchins and Lambert. Now, this was a case where unlicensed security guards were deployed. The two directors of the company knew that there were unlicensed guards being deployed, but they didn't have specific knowledge of a particular deployment or a particular guard who was on a specific deployment. This case was one where consent could be charged because there was a memo found within the evidence which showed that the directors knew that on a specific date, which was the date when all the directors had also, the guards had to be licensed, that the company knew at that stage that not all of their guards were licensed, and that the practice going forward would be that licensed guards or guards who were in the process of undergoing application would be used. So they had actual knowledge of what was going on, and they were complicit in allowing the company to do that. What the court did say in this case, though, was that the directors did not need to have that specific knowledge of actual dates and times when unlicensed guards were being used, because they said that if they had to have that specific detailed knowledge, it would allow directors, in effect, to shut their eyes to the management of their companies. So slide 4, please. So some conclusions that we can draw together from all of these cases, and you'll see that some of the cases are firmly directed towards neglect, some directed towards consent and connivance, are that if it's obvious which of the provisions apply, you should charge them. So you shouldn't just have a blanket charge every time of consent, connivance or neglect. If it's not obvious, it is acceptable to charge all three, and you shouldn't face any arguments about duplicity. What is clear though, and I hope that has been thoroughly picked up, is that if there is a question mark over knowledge, only charge neglect and don't bother with consent or connivance. Position if there's more than one director. If there's matters left solely to one director, then it's going to be very difficult for him to absolve himself of any liability. There's obviously only one director within a company, then matters are going to fall squarely on that person. So if you're thinking of which director, if any, if there are numerous directors or company secretaries involved, to charge, you may encounter a problem knowing which one to charge if, for example, they refuse to come in for an interview under caution. And in those instances, you may have to charge more than one director. But when you do have evidence to show that one director was in charge of a particular area, and that you can see that it was therefore his duty to act and that he should or ought to have known, then just charge the one director. It's not acceptable or appropriate to have a scattergun approach if you have the evidence to support one director being responsible. So what is needed to show consent or connivance? Actual knowledge of the exact nature of the conduct. What is needed to show neglect? If there's no knowledge, the question is not what did he know, but rather what should he have done or what ought he have done in the circumstances. What duty was upon him in a particular role? You can come away from slide 4. And as always, if you're struggling with any of these details, especially in the early stage of a case, remember counsel is always here to help.
Always.
Cameron,
Always here to help.
24 hours a day, we're always here to help. Cameron,
No question too big or small.
No.
Right. Well, we do have some questions.
We
You'll
do.
be pleased to know.
Okay.
We'll start with some of those from the live chat, and there's really only one question that's expanded over the chat from Emma Kirk. Now, I don't know whether that's Jonathan Kirk's wife, who is a gynaecologist, so I'm surprised she's tuning in, but if it is, it's a question nonetheless.
Might be what's for supper.
Yeah. But it's not, though. It's what's the difference between consent and connivance?
I think the difference between consent and connivance can be taken from the very first case we looked at, Huckabee. Consent is you have the actual knowledge, you know exactly what's going on, and you allow it to happen. Connivance is that slight step away. You have the knowledge of what's going on, but you sort of turn your mind away from it, or you turn a blind eye to what's going on. So as the the Divisional Court approved in that case, it's tacit agreement. You're aware of what's going on, but you agree to it, but you just take yourself one step away from it.
I, trying to be helpful at the time, as ever, typed a very similar answer into the web chat.
Glad to hear that.
And the follow-up is then, so is the mental element the same?
The mental element is in effect the same, and that is why in a lot of the provisions, like the one we looked at, Regulation 15, they split it into two. They have guilty by committed with consent or connivance, and then neglect separately. And I think in all the cases, I don't know if Cameron may have had a different experience, but in all the cases that I've seen, either conducting myself or reading case law, consent or connivance is always charged together.
Yeah, the practical answer is, as Alison already says, in my view, it is the same mental element. You have to essentially prove the knowledge. What is different is just the evidence that surrounds proving that knowledge, whether you've got evidence of a director actively encouraging and being truly involved in what's going on, or whether it's a director who is perhaps slightly more distant and tacitly encouraging or agreeing to what's going on. So it's an evidential thing rather than actually changing the mental element. We then have another question that comes via email from the wonderful surroundings of Norfolk. Lewin and Bland and Motor Depot versus Kingston upon Hull. Are these still relevant, and to what extent in your view?
They are still relevant. I did have something about those cases in my notes, but as the time was running a bit short, I didn't go to that. If I just turn to my notes, forgive me if I'm looking away from the
Lewin
camera.
and Bland was disastrous case for the prosecutor. I can't think who it was. Louis.
Yes.
No, doesn't ring any bells.
No.
But it was a disaster because they essentially charged the director of a company in relation to the sale of a second-hand car, and that director's defence was that he had delegated the task at hand and at issue to a senior manager. And the magistrate said, well, that's sufficient, he's not negligent because he's essentially complied with his duties there, he's delegated a task, it was perfectly reasonable to do so. And the ill-advised prosecutor, again, I can't think of who it was, decided to appeal it and got a shoeing around in the High Court, where essentially they said, dismissing the appeal, that the justices did not act unreasonably in taking the view that the defendant could expect the work to be completed in accordance with his instructions. He had no reason to think that it wouldn't have been. And so I think it's still relevant, but what it tells you is that you have to look at the facts of any given case, and you have to look at what the evidence shows and what you're going to be able to prove. So that's Lewis and Bland.
Motor Depot. I've got that again was a delegation point. I think it was to do with advertisements, wasn't it, Motor Depot?
It was.
And it was the director said, well, that's nothing to do with me. I delegated that to one of my fellow directors. But this was the managing director who was appealing in this case. And Lord Justice Elias said, it was a proper inference that in a company of this kind, for somebody who was treated as the boss and claimed to be managing director, and where the advertisements were so central to the business, there would be a duty on the managing director. Of course, that only raises what is in effect a prima facie case, which then is capable of being rebutted by the defendant going into the witness box and demonstrating that, in fact, there was somebody else who was responsible and that there was no reason to suppose he should be supervising the activities of that other person. So in that case, again, delegation couldn't be relied on, as we've seen, because the court felt it was such a central issue to the business that the managing director simply couldn't walk away and say that's nothing to do with me and leave it to somebody else.
Another follow-up question that's come. Someone's pointed out, I had no idea that the prosecutor in Lewis and Bland was Brian Lewis.
Oh, that's it.
Oh, yeah. So for a company with only one director, can that director blame employees?
Again, I think you would have to look at the circumstances. If it was a very senior manager, for example, it may be sufficient. I think, Cameron, would you agree with that? Depending on what that senior manager's role was, and whether, again, having looked at the case law, whether it was appropriate for him to delegate such.
Well, I think the short answer is that, the director can try and blame an employee, but that doesn't mean the evidence is going to stack up to help him in that, or her in that regard. A director simply saying, I told someone else to do it, isn't necessarily going to be complying with their duty as a director. And remember that the Companies Act puts specific duties on directors of companies to act with reasonable care and skill. So that's the starting point there. So I think, again, the point is you have to look at the facts and you have to look at the evidence and what it shows. And that's, for me, one of the most important aspects that is sometimes regrettably overlooked in these cases, where consent, connivance or neglect is simply charged as a trio with not a lot of analysis as to actually what the evidence shows and what you can prove, bearing in mind, in particular, evidence of the size of the company, the number of employees, the type of business involved, and therefore the reasonableness of a director delegating those tasks to an underling. So look at the facts. There's another question. Would it be appropriate to pursue a director who has no part in the running of the business but has just been installed for convenience by a de facto director who is banned? Ooh. Well, I have my answer. Do you want to go first?
No, you go first. You've got your answer.
Okay. Well, if you, upon analysis, come to the conclusion that this is a sham director, then you have to look at the evidence and who actually is behind the running of the company. That doesn't mean, though, that the sham director can escape their duties as a director of a company under the Companies Act. If they're therefore doing absolutely nothing, in spite of the fact that they're a director of the company, haven't involved themselves in decisions, have taken no action in relation to the apparent criminal activity being conducted within the company, then they're likely to be in neglect, aren't they? So I think that you would be able to pursue a director in those circumstances and might be able to pursue the sham director that underpins it as well. We have another one. If the director exercised reasonable care and skill and delegated work to a junior colleague, would that delegation stand? It, probably. In short, if the director exercised reasonable care and skill and you had a structure whereby the person they delegated the work to was an appropriate junior colleague, if he gave it to someone, for instance, or she gave it to someone with absolutely no qualifications, experience, or in reality skill to do the job that he'd given to them, then you might be able to fall on neglect, particularly if he doesn't then, or she doesn't then back up what's been delegated to ensure that the job's being done. But it's going to depend on the facts. We can't give you definitive answers to these sorts of questions because it will always require analysis of the facts and the evidence, in my view. Do we have any more? Not on the live chat, any more coming on email? No. Any from the live audience? Because we have an audience of about
production team
50 here. Thank you for listening in. I believe we've got another presentation, episode 3, on the 17th of August.
Yes, 17th of August, 11 o'clock. Jonathan Goulding will be presenting that day, I think with Michael Coley assisting. And the topic that day, actually quite neatly following on, is charging the right defendant.
Oh, look at that. Neat.
Look at that.
Neat.
Anyone would think we planned that?
Anyway, thanks for tuning in. We look forward to seeing you next time. Bye.